The Supreme Court has said that under trials cannot be detained indefinitely in prison if there is a delay in concluding the trial. The court said this while hearing the case of an alleged Maoist leader who was charged under the tough UAPA law and was in jail for 9 years since 2012. While granting the alleged Maoist bail, the top court said that courts are ordinarily obligated to grant bail if timely trial is not possible and the accused has been in jail for long. Stressing on also protecting the rights of the accused, the Supreme Court said that deprivation of personal liberty without ensuring speedy trial is not consistent with Article 21 of the Constitution.
This goes on to show that we are yet to achieve the basic concept of personal liberty in the country. The constitutional provision is there since inception. Personal liberty is the life of the Constitution, and we are unable to provide that life in a proper perspective even today. That's the most unfortunate part. The inmates are languishing. These under trial inmates are languishing for years altogether. This was only a case which came before Supreme Court, but this is happening in every district court in majority of matters. The bail applications are not being listed. And I'm giving you this example from my personal experience. For months together, a bail application did not come up before Allahabad High Court because of some rosters issues, because of something or another. A bail application is pending before Meerut Court for last 4 months. If this is the situation about the bail application, what about the conclusion of trial? So this is the practical problem what we face in the courtroom every single day. Yes, Supreme Court has been saying that bail is a right, jail is an exception, but this is not being adhered to either by the investigating agencies or by the courts below. That's the most unfortunate part. We are not able to, as Supreme Court rightly noted in that case, in this recent case, which is Ashim, two separate judgments came in 2 days. One is Ashim's case, which was by Justice Achir Rastogi's bench, and another is by Chief Justice Ramana's bench. In both the cases, the court noted that there has been lapse of time. Trial could not be concluded. There are around 298 witnesses. Why is this person languishing in jail? And there is no answer. And that's the most pitiable part of the system.
Geeta Luthra, senior lawyer in the Supreme Court, joining us on the broadcast. Good afternoon, Geeta Luthra. I want to begin by asking you that languishing under trials, languishing in jail for a prolonged period, and you just heard the personal experiences that Ramakant Gaur was sharing with us. 4 months bail applications remain pending. Now the Supreme Court has said that the courts would be obligated to grant bail if timely trial is not possible. Do you think that such a thing can come into force? What are your thoughts on the top court's observation with regards to under trials being kept indefinitely in jail?
You know, the Supreme Court, in an earlier earlier judgment, in fact, 2 earlier judgments, had at one time said under trials kept in jail, this is not good. Even not only should they be granted bail, they should, in fact, in cases of not so heinous an offense, they should actually be acquitted. So every once in a while, the court says it. But the rest of the time, the court does not say it. So, you know, the signals which the trial courts get and the sessions court get is to err on the side of caution. Now, caution means you keep the person in custody and you keep the under trial in prison. Now, that's actually not the criminal jurisprudence in every developed country is to the contrary. The jurisprudence says that actually, suppose you are going to acquit this person ultimately, suppose he's going to get discharged ultimately, there is no system of restitution. And how can there be a restitution of the ignominy you face being an under trial? Your family faces, people commit suicides, families, starve off, their children starve off, there's no source of livelihood. It's also the stigma of it all. So, of course, the court, bail not jail should be the principle. But the fact is, even if Supreme Court has said it, I feel many trial courts, many bail granting courts, session courts, in case of anticipatory bail,
Yes.
and high courts would still be hesitant, would still look twice. So I think...
Yes, but where exactly is the problem? Where exactly are matters stuck? Because the top court, it seems, have also noted that the executive and the judiciary should set aside their differences in dealing with urgent issue of how to reduce pendency of cases. You are saying that the trial courts have this tendency to err on the side of caution, but here we can very well see that it's been, this is taking it too far. The sense of proportionality is lost. When for every case, if it has to be, on the side of caution, the larger purpose is lost, isn't it? Whereas this top court, like you mentioned, time and again has reminded bail, not jail, should be the norm. Justice delayed is justice denied. Yet, where exactly do you think are matters stuck that we have not made any progress, no breakthrough in this matter?
Is that the moment, it's a heinous crime, you forget this principle of a person being an under trial. Now, persons are under trial whether it's heinous or less heinous. The fact is, he's under trial. There should be a presumption of innocence. And therefore, if you keep him in, and in India, there is hardly a principle even of compensation or wrongful, malicious prosecution. We hardly have any cases of malicious prosecution. We have so many acquittals. By that time, the person is so exhausted, done, dusted with the legal and judicial system that he doesn't even want to look at us to go on further to get his so-called retribution that he may want, which can only be in financial terms because you can't give back that time.
Yes.
So, I can only say that it's really to be appreciated that the Supreme Court has reiterated this, which is, according to me, in criminal law jurisprudence, an important aspect which countries like the United Kingdom or the United States have been following very, very sincerely and very strongly.
Right. Geeta Luthra, thank you so much for joining us on the subject and giving us clarity on a number of issues. I want to welcome Aniket Nikam, senior lawyer, joining us as well on the broadcast. Good evening, Mr. Nikam. Where do you stand on this? The issue keeps coming up, but it becomes business as usual. There is no forward movement. The top court has, without mincing words, said bail, not jail, should be the norm. We all know the cliche, justice delayed is justice denied. Yet you have situations where under trials are languishing in jail for years. The issue keeps coming up. The top court keeps making their observations, but nothing moves.
The top court has again reiterated the golden principle, as you rightly said, that bail is a rule and jail is an exception. And we owe more than verbal respect to the principle that punishment begins after conviction. And also that every man is deemed to be innocent until duly tried and duly found guilty. However, we have been seeing cases where people who have been tried for offences punishable under sections like 420, for which maximum sentence is 7 years, and we have seen them languishing behind bars for more than 5 years. The trial have not commenced. It is a very sorry state of affairs. So we need to sensitize towards this aspect, and it's very important that what time and again Supreme Court has said, that detention in custody pending completion of trial could be a cause of great hardship. It violates the right of liberty of the accused who is being detained behind bars without a trial. Therefore, we need to really, introspect, make certain changes in terms of law of bail to ensure that the object, and you have to also remember that the object of bail is to secure the appearance of the accused at the trial. It is so bail is not to be denied by way of a mark of his conduct or to give him some sort of punishment before trial. So all these aspects will have to be again looked into. We need to introspect. We need to make certain changes to our code of criminal procedure in order to reach to this goal of bail being the rule and jail being an exception.
Yes, Aniket Nikam, appreciate your joining us with your informed opinion on this subject. We'll continue to track developments on this front and try and understand why, despite many reminders, things on ground have not changed so far. Now, that will continue to be our focus. Thanks very much for now.